SJC-13437, Conrad Murphy v. Carol A. Mici and others.
Good morning, Madam Chief Justice and members of the court. In enacting the medical parole statute, the legislature was concerned with providing a potential avenue for release for prisoners who became debilitatingly ill and whose only other recourse was an executive clemency process, which was highly discretionary, and as this court noted in Harmon and in other cases, largely unsuccessful, highly unlikely to lead to release. And this court, in construing the medical parole statute, determined that prisoner, as that term is used in the statute in Harmon, the court said it applies only to committed offenders serving a criminal sentence. And that interpretation does not frustrate the legislative intent of the medical parole statute, which is to provide an avenue for those prisoners who have no other recourse. Commissioner Mici.
Just one fact point. He's already finished his criminal sentence, right? He is just being held at Bridgewater as an SDP, right?
He is civilly committed as a sexually dangerous person.
Right.
So therefore, he's seeking release through the wrong statutory process, through the wrong decision maker. And Commissioner Mici was correct in rejecting the medical parole petition because under this court's own determination, he is not a prisoner as that term is used. And this court rejected the definition of prisoner contained in Chapter 125, Section 1M, which has a broader meaning. And in Justice Gaziano's opinion in Harmon said, we reject that. The context otherwise requires. And that was for pretrial detainees.
So assume that's right for a moment.
Thank you.
It was unanimous.
Yeah.
It was unanimous.
Yeah, you joined it.
Pretrial detainees and civil aren't paroled. Assume all that's right. Is the problem here that when you get to the constitutional issue, it's not equal protection being argued, but substantive due process?
There was a substantive due process claim, as we understood it, raised below, but there is no
equal protection.
At the Superior Court, at the hearing at the Superior Court, there was a discussion that could be tinged as equal protection, and the amicus certainly brings up equal protection, but there is no equal protection violation. SDPs, sexually dangerous persons, are all held on a finding beyond a reasonable doubt that they are likely to reoffend due to a condition, a mental abnormality or personality disorder, and therefore they are not similarly situated to ordinary inmates under sentence for whom there is no such finding. So there's no equal protection issue. And as for substantive due process, SDPs have available to them, this particularly menacing subset of sex offenders have available to them a robust process that this court has found to comport with due process through Section 9.
What's the alacrity with which that robust process works when the civil detainee is saying, I need my Section 9 hearing, I need my qualified examiner really quickly because I am medically unable to reoffend? And
a petition can be filed, and it can be filed by the department, and it has been filed by the department on occasion. A petition can be filed, and a trial will be given. And in the ordinary course, probably about a 2-year time frame. However, the SDP has available to him the opportunity to move to expedite the qualified examiner evaluations. The qualified examiners, as this court has said, are the independent, accountable experts. They serve as the gatekeepers to that process. And if the qualified examiners opine that the person is not sexually dangerous due to age, infirmity, or some other combination of factors, the SDP is entitled to unqualified release from the SDP commitment.
So if the person is like Chapman, for instance, right? That's the case at all. So if the person is so ill that they would get medical parole, were they a prisoner, the two QEs you posit would say this person has 3 months to live, essentially.
The qualified examiners have access to the medical records. They have access to all records by statute of the person being evaluated. And routinely in cases where medical issues are of concern, and the court's own record in Chapman shows this, consult with the medical providers, review the medical records, interview medical staff at different times depending on the circumstance and questions they might have, and render those opinions. And as the record in this case shows, although Mr. Murphy did not avail himself of that.
So it seems like the issue is the time is the only difference in the process is the time, right? And does that mean you have a right to expedited review, and if you don't get expedited review, there's a problem? Because I get your argument that this person's no longer a prisoner. His criminal sentence is over with. He's only being held civilly. And now we're dealing with the issue that sort of bothered the trial court judge, which is there's no way, you're not guaranteed that expedited process in the SDP context that you're guaranteed in the medical parole process.
Well, there's two differences, and I just want to address the first one first, which is who is the decision maker? So in the medical parole context, the discretion is vested in the commissioner. In the SDP process, which this court has said requires expert opinion, it requires expert opinion on the way in, and it requires expert opinion in the discharge process, because the conditions at issue are not conditions that are susceptible to lay judgment. They require expert opinion. So that is one distinction. But in terms of the timing, and there's no record here with respect to Mr. Murphy because he did not avail himself, despite suggestion from the defendants, that he had the opportunity to seek expedited qualified examiner evaluations. And as the record in the defendant's 16L letter shows, he was found to remain sexually dangerous at the jury trial in July.
But so back to Justice Lowy's sort of original question, though, about substantive due process, or I don't know, there's a cruel or unusual punishment component to this, too, I think, argument. So if we have a dying SDP, he's got leukemia and he's going to be dead in 4 months, does he have a right under the Constitution to an expedited review, because otherwise he's going to be dead before he can be released?
He has a statutory right to seek to expedite his case, and as Justice
But what happens if they don't? Do we deal with the issue of, because it's all discretionary, right? You point to the fact that he could get one.
Yes.
Again, I'm unlike my colleagues who sat in those sessions in Superior Court. My sense is they're quite backed up. And do you have a constitutional right to expedite that thing when you're being held as an SDP, which is a civil commitment after you've finished your criminal sentence?
You have a right to a speedy hearing, and that takes into account a variety of factors.
What does
and what
that
is
mean?
Speedy? So there's not a set deadline, and this court's cases from Trimmer to Lesage have never set a time frame. However, one of the reasons you don't see speedy trial cases on these matters very often is because of the way that the actual SDP session works. And for the benefit of those of you who haven't sat in the session, it's a unified session, so all Section 9 petitions are concentrated in Suffolk Superior Court, where they're managed, and they're generally assigned a trial date as the next petition date in order that the petitions are filed. But as the record in this court shows, when it is appropriate to file a motion, and there have been joint motions to expedite, there have been assented to motions to expedite, qualified examiner reviews, then the court largely grants those.
Yeah, but let me ask Justice Kafker's question in a slightly different way. What is the best case scenario, how quickly you can get 2 qualified examiner reports?
Typically, and we haven't had a case where death was imminent, so I just want to be very clear. Typically, we would typically ask and have agreed to 60 days, which is shorter than the medical parole statute process by 6 days. Typically, we would agree to 60 days. Sometimes it's a little bit less, depending on a variety of circumstances. It could be a little bit longer, but we have typically agreed to 60 days, and that's what you see in the record of the other examples that have happened.
I'm sorry, what are the circumstances under which you agree to the 60 days typically?
So,
When the two QEs say something?
no, the QE evaluations would be triggered by this expedited order. Typically, it would be when the Community Access Board, which reviews SDPs annually, and if the CAB renders, the Community Access Board, CAB for short, renders an opinion that the person is not sexually dangerous, and if the person is...
That's the problem, isn't it? I'm not saying it is a legal problem, but it's a practical problem. So you've got, again, somebody gets, you know, that terrible diagnosis that they're going to be dead shortly. They're really, you've got to pick the QEs, right? Got to pick the QEs, they got to analyze them. But is there really a realistic 60-day process, or what you're describing is something that happens when it's already teed up? Meaning, right? I mean, again, I get my diagnosis or whatever. You get the diagnosis that you're dying or that you're paralyzed and you can no longer cause any trouble. Can you really do this in 60 days?
The qualified examiners, yes, and it has been done on multiple occasions, I think 7 times in the last year.
Multiple occasions from the moment you learn that you're dying or that you're physically incapable of the predator behavior you demonstrated before.
So 60 days from the date that the court orders it, the request is made. And typically, I'll give you an example of one of the ones that's in the record.
Could you finish the answer, please?
Yeah,
Thank you.
60 days from the date that the request is made to the court, which would typically come from either the Commonwealth reaching out to the other side's attorney or the attorney reaching out to the Commonwealth and the court. But yes, 60 days is the time frame that we have generally requested. If there's a reason to suggest 45 days, but to be clear, you want some reasonable process, which is why even in the medical parole statute, it's not, here's the petition, act on it tomorrow, because you want to have a reasonable process so that the risk to the community is looked at, as well as whether the medical condition is debilitating, whether for the purposes of an SDP finding or medical parole.
That's very helpful. I just want to understand. So if your opposing counsel had sent a letter to the court saying, you know, my client's dying, then within 60 days you can create a QE review and tee this up so that we don't have the timing problem that bothered the trial judge in this case.
Yes, and that's normally what we would agree to when we, and as you can see from the record, assented to or joint motions, and generally speaking, we work with the opposing attorney to pick a date that's reasonable based on the medical condition as well as the need to get the evaluations completed.
Can I ask you, would you agree that we should clarify the time standards to satisfy substantive due process in these circumstances?
No, because there's not a record before you that there's any due process problem here. The petitioner, Mr. Murphy, never sought to expedite the SDP process, and Judge Hom in the Superior Court alluded to one of the reasons why not, because an SDP might not want a QE saying that he remains sexually dangerous, which would ultimately not very much help medical parole, even if he were
so we need to wait
relevant for it.
We need to wait for a case where this issue is raised.
Yes. And one of the reasons you don't see cases like with this issue raised is because the process works so well in the Superior Court. And anybody can bring a motion to advance their petition. As Justice Cowan said, sitting as a single justice in Pentlarge in this court, before you can advance it ahead of anybody else, then you need to show a likelihood of success. With a medical issue like that, as the record shows, they're assented to and joint motions on occasion. But it's not, that issue is not right because it's not before the court.
I understand that point. And just would be a lot more comfortable to have a record that says an expedited QE report is going to get to basically the same place as a medical parole evaluation in approximately the same amount of time.
Right, and that's And that's what the record shows in other cases where such a remedy was requested. But even if the court were inclined to find...
Are there any published decisions related to that? Do we have any guidance out there where that happened? Even Superior Court decisions that we can turn to on that?
Superior Court decisions where the order was...
Just what you said happened.
In the record itself, we have included in the record instances where expedited requests were made. They were either joint motions or assented to motions, and they were granted. And by my count, according to the court records that we have, there were 7 such instances where motions were made last year, not all of which may be in the record, but certainly the court could take judicial notice of the dockets, and they were all granted, and the cases then proceeded. Because once you have a qualified examiner opinion, then the Commonwealth can proceed to trial, which would tend to suggest that the condition does not warrant release, or at least a fact finder, the jury should decide that.
But if a person clearly has 6 months to live and the 2 QEs come back and say they're no longer sexually dangerous because they're so infirm, the person's released.
The person is unqualifiedly released from the from the SDP commitment, and unless they're held on some other custody awaiting trial for something, they would be unqualifiedly released to the community. But even if the court were to be concerned about that, the remedy for a problem in the SDP process is not to expand the medical parole statute beyond what this court has already said it applies to. That would be the province of the legislature, and in the nearly 2.5 years since Harmon was issued, the legislature has not amended the statute. And because the SDPs have a robust process to seek release, including to expedite it, and I would invite the attention to Justice Cowan's opinion in Pentlarge, included in the record, because they have a robust process, there's no constitutional violation here.
Okay, thank you.
Thank you.
Attorney Coase.
Good morning, Your Honors. May it please the Court. Matthew Coase here on behalf of the appellee, Conrad Murphy. We are asking this Court to uphold the Superior Court's decision, which merely gave Mr. Murphy the opportunity to be released on supervised release and that his medical parole petition be reviewed and considered on the merits.
Well, given the holding in Harmon, I don't understand that position under the statute.
Well, I'm glad you asked that question, Justice Wendland, because I think that I read Harmon to be a little bit different. I see the analysis under Harmon as being kind of a 2-step analysis. We first look at the question of whether or not the individual qualifies as a prisoner. And that definition is a committed offender and such other person as is placed in custody on in a correctional facility in accordance with the law. And that's
Less context requires.
Exactly, Your Honor, unless context requires. So I think context does matter in this case. I think you have to look at the nature of individuals who've been civilly committed under Chapter 123A. And I think you also have to look at the nature of the sexually dangerous proceedings and the medical parole statute itself. So
We've said time and time again that they're civil commitments.
That's correct. But I would suggest in the context of medical parole, they would be, that they should qualify as prisoners under the more broader statutory definition under 125 Section 1, as opposed to what is required under 123A to get the...
Well, didn't we already reject that, doing that in Harmon?
In Harmon? I disagree, Your Honor. I think that Harmon was specific to pretrial detainees.
Oh, I know that was what the subject of Harmon was, but if Justice Gaziano discussed on behalf of the court, very much so the nexus between that term and parole, and that parole was the chief driver here. And clearly, when you're talking about someone who's already committed a sentence or done a sentence, finished a custodial sentence, and now they're being held civilly, they're not on parole. So how could you work backwards and shoehorn sexually SDPs into the definition we laid out in Harmon for prisoner?
Well, again, I think that they do meet the broader definition under 125 section 1M. But again, as the statute itself says, context matters. So sexually dangerous persons are essentially serving an extension of their original criminal sentence.
Okay, that'd be a due process violation. That's a double jeopardy violation. Come on.
Not doing that. Matter of fact, I mean.
That would be unconstitutional. We said it.
DOC, I mean, maybe you had a better argument when DOC was running the treatment center, I don't know. But it's not an extension of a criminal sentence. It can't be.
I'm arguing from an objective standpoint. We have
Well, try a legal standpoint.
It isn't.
Well,
So assuming that argument isn't going to hold water with this court, can you explain to me why, I don't really understand your substantive due process argument. Can you explain that?
well, I think the substantive due process argument is essentially born out of the concept of equal protection.
Well, those are two different concepts. So can you stick to one? Which one is it? Equal protection or substantive due process?
Well, I think the substantive due process gets to the context of the medical parole proceedings as Judge
your opposing counsel did point out, I thought quite well, that they are differently situated. SDPs are differently situated than your garden variety inmate. Do you agree with that?
Correct.
Okay, so given that, how could it be a substantive due process problem to treat them differently? Or how does it shock the conscience to treat an SDP who has a whole series of other procedural protections, beyond a reasonable doubt, annual reviews, different than the regular inmate?
So there's no process under the SDP statute which allows the civilly committed individuals to be reviewed or evaluated solely upon their medical condition.
No, but doesn't it tie to the fact to whether or not they continue to be an SDP, whether the public continues to be at risk because of this person? If they're so incapacitated by their medical disability that they can no longer function, doesn't that have an effect on whether the QE is going to be able to say that they are still an SDP?
Correct, Your Honor.
So it is part of that process that's been laid out by the legislature.
It is part of the analysis, but it is not the entire analysis. The entire analysis under Chapter 123A is mental abnormality. So
anybody with a mental abnormality is an SDP?
A mental abnormality that kind of propels them or compels them to commit some sort of repetitive sexual.
What about Chapman?
Pardon?
What about Chapman?
Well, I think Chapman is a good explanation or example of why an individual who is physically incapacitated or terminally ill may not render themselves sexually dangerous. But I think it's the process here that is different. Ultimately, in the Chapter 123A process, these individuals are looking for absolute freedom, where under the medical parole process, they're looking for supervised release. It's a much speedier process. It focuses more on the medical condition, and it provides individuals.
But if these people are differently situated, as you just agreed, why are they entitled under the Constitution, U.S. or otherwise, to the same process?
Well, perhaps I misspoke when I said that they were differently situated. I think when you look at individuals who are civilly committed, they're in a building which is secured by the Department of Correction. They're a lot of times, such as in Mr. Murphy's case, he's in a building or a unit that also houses other prisoners who are serving their sentences. They're subject to many of the same rules and regulations that individuals who are serving sentences.
And they also get once annually a possibility of getting out. Do the inmates have that?
Inmates do not, but I think
so
that
they're differently situated. They're there under different rules. I guess I still don't understand the Constitution.
And they get a better deal. They're not, if they get released, they're not subject to the parole process. So again, back to your substantive due process or cruel or unusual punishment or equal protection argument, the only issue that bothered the trial judge and seems to be an issue was the timing, but your sisters just got up and said, you can get this done in an expedited way, so there can't be really a constitutional problem based on timing here. So is this like a solution in search of a problem, or I don't know, or a problem in search of a solution? It just doesn't seem to make any sense that we're going to warp one statute when we have a statute that works perfectly fine that's directed at the problem.
Well, I disagree with that, Your Honor, because the timing that my sister elucidates on, sounds attractive, but I don't think in reality it can always be the case.
But do we have a record for that to decide that issue?
Well, I would point to the record that
Because you didn't raise that below, right?
Did not raise that below, Your Honor.
My concern, I think you might be, and I think Judge Hom focused on that, and it's worth talking about, and it may be meritorious. But in order for us to do so, we need to know, is this solution that Ms. Murray tells us is the constitutional answer, is it illusory in that expedited doesn't mean expedited, you jump the line, which I think is a line for what you said in your brief, so that we really can't hang our hat on that, but we just don't know because you didn't raise it and there's no evidence below as to what went on, correct?
I think that's fair, but I would point to the statute itself. I think we can look to the statute and look and see if there's anything within the statute, 123A, that allows for expedited.
Expedited is in the statute, correct?
Well, I believe it says speedy hearing, but I think we have to kind of look at, what the statutory language is and then also look at, reality.
I'd hate to make a constitutional rule in the dark where we don't know. You may be right, it may be expedited means 120 days, and we have people who are infirm who should be released who aren't being released, and then we'd have constitutional issues of substantive due process and/or equal protection, but we just don't know given the posture of this case. That's what troubles me.
Well, I would say that the examples that the defendants have given in this case, don't necessarily show all of the possibilities. They're talking about joint motions or assented to motions that may have been filed. There could certainly be circumstances where a civilly committed individual would have severe medical issues, and the defendants might, or the Department of Correction might choose to oppose it. And a judge sitting in that session might want to...
we could have one QE says yes and one QE says no, right? That could be a
That's correct, Your Honor. Or a judge might say, well, I don't know if I want to expedite this particular Section 9 case and jump the line unless we have concrete medical diagnosis and a concrete medical opinion.
No, but you're the one saying that if your statutory argument doesn't work on prisoner, and it's a pretty steep hill, you're the one saying that there's a substantive due process problem. So I think the record has to come from you that there is, that this expedited QEs aren't going to ultimately get to the same issue as to whether this person is so in such a state medically that they're not going to reoffend, and it gets you to the same place as medical parole. And by the way, that's an easier standard than medical parole, because in medical parole, even if you satisfy the medical issue, the Commissioner of the Department of Corrections still has to analyze the welfare of society of the release. So the Section 9 route actually might be easier to satisfy than the medical parole route. It doesn't have that welfare of society overhang on it.
Well, I would argue against that in two ways. I think one is the timing issue. Again, we have kind of the best circumstances that have been laid out by the defendants in this case, but there could be situations where it gets drawn out. And also, an individual who's been civilly committed doesn't have the opportunity to seek reconsideration.
Can I ask you just a quick question on this? In what part of substantive due process jurisprudence is there anything about the time that requires the government to act within a particular 60-day window, 120-day window? I don't understand the nexus between the time that you're arguing for and substantive due process or any of the law in that regard.
Right. So the Superior Court's concern in this particular case was twofold. It was the length of time and the opportunity. And so in the statute, it sets forth an opportunity for individuals who are also in custody, and they get this opportunity to go before the commissioner and present their petition and have it judged on the merits. That same particular opportunity is not available to somebody who's civilly committed. And also the process that's in place through 123A does not...
Don't know where in substantive due process jurisprudence I might find it has to be done on 60-day window or 120-day window, and it has to be done by this particular decision maker, the commissioner, as opposed to beyond a reasonable doubt at trial.
Not in the medical parole context. I think this is a unique case, and we're asking that it be
for the first time, yeah.
Because the time standards all revolve in Buckman around the statute, correct?
That's, I'm sorry, Your Honor, could you say that one more time?
Buckman, the medical parole statute, when we talk about the time standards, it's meant to meet the legislative mandate of giving meaningful medical parole before people die, essentially.
Exactly, Your Honor. And I think just to conclude...
But doesn't that also shift you to the SDP statute? Because there you have a better substantive due process argument. This person shouldn't be in the treatment center unless they're dangerous, because they fulfilled their criminal sentence. That would be the substantive due process thing. The person's dying and is no longer dangerous and shouldn't be in jail. That's your best argument. But that shifts you over to the SDP statute as the appropriate place to deal with this, doesn't it?
I disagree, Your Honor, because I think that the SDP statute doesn't adequately address both the resources that are available under medical parole and the timing issues that are in there.
But that gets back to Justice Gaziano's and Justice Lowy's point about the absence of proof and how that plays out. Because you haven't shown that the other process doesn't work. I don't know which way that cuts. You haven't raised the issue that they can't do it in an expedited way over there in the SDP. And therefore you want us to find that we have to treat these SDPs under the medical parole statute. I just don't know if that works when you haven't proven that the SDP thing doesn't work on its own.
Well, Judge, I recognize that we're stuck with the record that we have on this particular case. But I would, again, point to the SDP statute that says speedy hearing. But what we know through Lesage and the other cases is that in Mr. Murphy's case itself, we're looking at about 2 to 3 years. And we never know what might be right around the bend. Mr. Murphy could suffer a stroke shortly after his SDP trial or after the QE evaluations, and he would have no recourse to have a second look at it where he would have if the medical parole statute were in play.